Well, another victory today for critics of the controversial indefinite detention law. A federal judge has ruled that the government cannot use that law to hold people in military prisons indefinitely. The ruling comes after a group of journalists and activists sued the government over the provision. They say it's unconstitutional and fear that they could be indefinitely detained under the law because their jobs sometimes require them to interact with terrorists. Well, the government interpreted an injunction put in place by the judge a couple weeks ago to apply only to a handful of plaintiffs in the suit. But now the judge says no, this is to be applied broadly to Americans. To discuss what this all means for your rights, one of the plaintiffs joins me now. One of the plaintiffs in the case, Tangerine Bolin, is the founder and director of Revolution Truth, and she joins me now from Oregon. Welcome, Tangerine. So want to get your reaction to the judge's ruling.
I'm grateful for that reaction. It's it's a good one.
Okay, Tangerine, an interesting argument that the government tried to make. They requested that this injunction only apply to you and your fellow plaintiffs, but the judge just made it clear that this ruling is to be applied broadly. And we have a little quote from that ruling. It states, quote, "The Supreme Court has made it clear that when a plaintiff claims that a law is facially vague and violates his or her constitutional rights to due process, that party seeks to vindicate not only his or her own right, but those of others who may also be adversely impacted by the statute in question." So, Tangerine, what do you think about that? The judge saying, you know, this isn't just going to apply to you and your plaintiffs, but this is going to be applied across the board in the U.S.
Well, obviously, that's what we were aiming for. We're not just fighting for our own First and Fifth Amendment rights. We feel that we represent thousands, if not tens of thousands of people across the country who are also similarly concerned. So that ruling or that clarifying order makes sense to me. Of course, we didn't come forward just for ourselves, although we did demonstrate harm, in her opinion, to these plaintiffs, including me. So,
what do you think about the government trying to shape it that way, that this is going to only apply to that few people?
It seems to me, and I'm just guessing, but as if they are trying to maintain the authority to have a very broad interpretation of this statute. And that's precisely the issue here. We are questioning that incredibly broad potential for a broad interpretation. And the judge is saying, no, that's not how we're going to look at this so far. So. Yeah.
All right. Tangerine, let's talk about what this bill is all about. It has stirred a lot of controversy, the greater implications of the NDAA, and why Americans should be concerned about the controversial, provisions in this law.
Well, I can only speak from my perspective, and I'm not an attorney, but what I can say is this. I approached Chris Hedges and his lawyers because as an activist working on civil liberties and someone who has heavily defended WikiLeaks and Bradley Manning, I have very serious concerns about the vague language in that particular statute. So the implications going forward, if the United States government wins this case, then I don't know what could happen, but what I'm afraid could happen is that people who are advocating for civil liberties like myself could end up getting swept up under the NDAA and indefinitely detained with no access to counsel, which is very un-American. That's not the American way. It's not how we do things here, and I want to protect our Constitution. So hopefully we win the case, and that won't happen.
And speaking of un-American is the word you just used, critics say that this law is also unconstitutional. What rights do you say it puts in jeopardy?
First and Fifth Amendments, definitely our freedom of expression and speech and due process. Again, I'm not an attorney, but to me, this statute rolls the United States back 800 years to pre-Magna Carta days. We've had due process for quite a long time. To put forth a statute that says we can accuse you, provide no evidence, and then indefinitely detain you with no access to counsel, it's unfathomable. I can't imagine what the Congress and executive are thinking.
Now, I want to bring attention now to something that happened just yesterday. This happened in Colorado. Police reportedly responded to a bank robbery by arresting dozens of people. And reports suggest that the cops trapped as many as 40 cars and handcuffed at least 19 people, most of them or all of them presumably innocent. They were held at gunpoint as they searched for a suspect. Let's take a look at some of the coverage of this.
Police pin in this group of cars. Drivers are ordered to get their hands up.
And they got behind shields. They had the M4s, shotguns out, taser guns, everything.
We didn't know what the heck was going on. We didn't know if we were in the line of fire.
One by one, drivers are pulled out at gunpoint and handcuffed. They're told nothing as their cars are searched.
So some of those detained say they were held without charges for hours. So is this an example of what can happen under the NDAA?
You know, I don't know. That might be a bit of a stretch because it's a bank robbery situation and I don't know the details. But certainly, yes, in the future, if the government wins this case, then all kinds of things could happen. I mean, they don't have to put forth evidence for calling you an associated force of a terrorist. And I just think that that's incredibly dangerous, which is why we brought the suit forth. So I'm not sure about the bank robbery situation, though. Sorry.
All right. Well, you know, as a journalist, do you feel better? Do you have more peace of mind knowing that this order has been put in place?
Yes, I'm really grateful for Judge Catherine Forrest's very firm stance on this and her clarifying order yesterday. What I'm dismayed over, though, is that the government attorneys are still doing two things. One, offering no evidence, no witnesses, no documentation, seem to be insisting on maintaining that right to offer no evidence. And two, in their motion for reconsideration they issued a few weeks ago, asking her to reverse her ruling, they described independent activities, independent journalist activities, independent advocacy, but they don't define independent. What is independent? If I've talked directly with WikiLeaks staff, is that considered independent or not? I mean, it's such a gray area, and it looks like the government is really trying to do its utmost best to maintain this gray area and their authority over how they wish to interpret that gray area. And that's of great concern to me and others who've seen this war on terror become more and more surreal over the last decade. And the definition of terrorism seems to be expanding as well. We can see that in some of the court cases that we've seen. So we want to just kind of stand up and say, wait a minute, let's examine this. This is scary. So I'm dismayed by the government's response. I'm surprised.
Now,
it seems a little arrogant.
At least this is a victory, another victory for you and critics of the NDAA and your fellow plaintiffs. Ultimately, what would you like to see happen in court?
Oh, yes. So definitely a permanent injunction on Section 1021B. That's what we're aiming for, and that's what we'd like to see. That would be a win for all of us, for hopefully U.S. citizens and people around the world who are innocent people exercising their rights. So that's what we'd like to see.
All right, Tangerine, thank you so much for coming on the show. That was Tangerine Bolin, founder and director of Revolution Truth.